Ross, a lot of times when I meet people, they ask me, what's a felony? Could you give them a concise explanation of that?
Yes, a felony is essentially a serious crime, a crime that the prosecutor's office at the county level takes interest in and decides to prosecute. To be distinguished from a municipal court offense or a disorderly persons offense, example would be a shoplifting or a minor marijuana charge. They would not be considered felonies. They would be handled in the municipal court. But something more serious would then be handled by the county prosecutor's office, and it's called a felony. And felonies are graded in New Jersey, as in most states. They're graded with the lowest felony being a fourth-degree felony, carrying a maximum term of imprisonment of 18 months. Then you have third-degree crimes, which carry up to between 3 and 5 years in New Jersey State Prison. Then you have second-degree crimes, which carry between 5 and 10 years in New Jersey State Prison. Then you have first-degree crimes, which carry anywhere between 10 and 20 years in New Jersey State Prison. And then there's 4 other crimes that fall even beyond first degree that have their own sentencing structures, and they are murder, carjacking, a leader of a drug trafficking network, and kidnapping.
Now, people often say to me, I got indicted. Could you explain if there's a difference or what the difference between indictment and felony is in this state?
Yes. An indictment is where your charges are brought before a grand jury and they're formalized. There's 2 ways to handle a criminal case, a felony case, and that's pre-indictment or post-indictment. The only difference being post-indictment is after a grand jury has looked at the evidence and decided whether there's probable cause to bring the charges and formalize them. And that's what the indictment process is. In New Jersey, it's a secret proceeding, which means that the prosecution convenes a grand jury and only calls witnesses that would benefit the state. The defense attorney and the defendant are not present at a grand jury, so there's no opportunity for a defendant to present his side of the story. So it's essentially a one-sided proceeding, again, the purpose of which is to formalize the charges. Now, oftentimes we handle cases before indictment, and oftentimes we find that we get better results, and it gives us an opportunity to present mitigating factors to a prosecutor before a case goes to the grand jury and gets formalized. But there's really no difference between an indicted felony and a non-indicted felony. A felony is a felony.
You know, as a matter of fact, the grand jury proceeding is so lopsided that I often tell clients that a ham sandwich in the state of New Jersey could get indicted.
True.
People often say to me, in very common in domestic violence or aggravated assault situations, people say to me, gee, the person I beat up or the person who says I hit them wants to drop the charges. Does that mean that the charges just go away?
No, I've experienced that quite often, and that's not the case. A victim of a crime is not the person who brings the charges. The victim of the crime is essentially the state's chief witness. The prosecution, the police department initially, and then ultimately the county prosecutor's office is the entity that brings the charges. The victim, therefore, is in no position to quote-unquote drop the charges because they're the state's chief witness. So I'm confronted with that oftentimes, that my clients will tell me, oh, the victim wants to drop the charges. And unfortunately, it's not that simple, and the system does not work in that fashion.
Now, people, I don't think people truly understand what their options are after they're indicted. I believe that once they come to Congigliotti and Associates, there are certain courses of actions that you have. One is that we could try our best, if the circumstances permit, to have those charges dismissed against the person, or downgraded, meaning reduced from a felony charge to a misdemeanor and or disorderly persons offense, or perhaps sometimes sent back to the municipal court, meaning the town in which the incident happened. But the fact of the matter is that in 99% of the time, a criminal defendant is faced with two choices, right? One choice is to work out a plea agreement or go to trial. And in the state of New Jersey, although trials are common, they're also a matter of last resort. Quite frankly, if I have enough information to defend my client effectively at a trial, I should be able to convey that information to a prosecutor and get somebody an extraordinary deal without having to subject them to the cost and the stress of a trial. Of course, sometimes there is no option except to go to trial. And when that happens, we get ready, we pick a jury, and we go ahead and try cases.
Now, Michael, it's true, is it not, that you haven't lost a trial in 12 years?
Yes, I've been very fortunate. I have not lost a jury trial in a little over 12 years. Most of those trials have been either murder cases or attempted murder cases, with a couple of serious aggravated assault cases thrown in there.